thank you, first of all, for inviting me to what is a fascinating day. I've put together quite a few slides, which I'm going to sort of race through in this session, and we can unpack some of the detail perhaps later on this afternoon. I've deliberately not used the phrase self-neglect in the title to this talk because I think there's a lot of sort of really interesting issues that we might want to think about during the day as to the sort of terminology that we use. Obviously, self-neglect is used as, and it covers quite a broad range of various issues. And to me, I think there's an important distinction to be made between self-neglect and neglect, because self-neglect would tend to suggest a sort of situation where someone has unmet need and they are able to make their own decisions about whether or not to have those needs met, and they are willing to do whatever it is they've chosen to do. So it suggests a very deliberate and capacitous decision that they're making. Whereas a situation of neglect is where perhaps someone is unable to make those sorts of decisions. So that's something we can perhaps think about later. In terms of balancing, from a legal point of view, in these sorts of cases, the balance that we often see is between autonomy and dignity. A lot of the cases obviously refer to autonomy, which is a fundamental principle. But perhaps equally fundamental is the legal principle of dignity. And if you have a situation where someone has unmet need, often that is the sort of, from a legal and ethical point of view, the balance that we are trying to strike. So this talk is all about challenging either incapacity or capacity determinations. So I'm focusing very much on the scope, remit of the Mental Capacity Act, which is obviously something that has arisen in safeguarding adults reviews. And my practice is primarily in the Court of Protection as well as in the High Court. And so in this sort of context, typically a case of very, very high risk will come in, and we will have to first consider whether the person is able or unable to make the relevant decision, whatever that might be, because of a mental impairment, in which case we end up in the Court of Protection. But equally, some of these cases involve people who are unable to make a decision, but there is no mental impairment. Maybe they're unable to decide for some other reason, in which case, if they're vulnerable, we end up in the High Court. So I'm focusing on the Mental Capacity Act and the Court of Protection, but it's important to recognize, and we can explore this in the workshop this afternoon perhaps, that there is another legal framework out there, the inherent jurisdiction of the High Court, which is a sort of great safety net to protect vulnerable people in certain circumstances. Anyway, this is all about capacity. And just in terms of terminology, because you might be wondering, well, what's a determination? You'll probably hear a lot more about this in the months and years to come, if and when the liberty protection safeguards are introduced. But essentially, and increasingly, what we are using are these terms assessment and determination. And there's nothing confusing about it, really. An assessment describes the process of working out whether someone can make a decision, and a determination is the conclusion. Okay, so assessment is the process, determination is the conclusion. Okay, so this is what I want to do in the next sort of 40 minutes or so. Four things, really. First of all, just set the scene in terms of some of the common errors that tend to be identified in some of these really complex capacity scenarios where there's unmet need. I then want to, secondly, look at the 3 principles of empowerment. We can do that fairly quickly because that will be very familiar territory to you. And then thirdly, have a look at what is the matter that requires a decision in these sorts of contexts, and what information is relevant, because I think sometimes that can be quite a challenge. And sometimes there are issues around fluctuating capacity, so-called executive functioning, all of which I want to have a think about. And then finally, when to challenge a capacity determination. And you'll see that there are certain common themes, I think, coming through these various talks. So the first error that's sometimes made, which has already been touched on, is that there is actually no assessment done of a person's decision-making ability, despite there being grounds for concern. And I'll say a bit more about this in a moment, but essentially we do have various SARs where, despite there being grounds for doubt or concern about someone's ability to make decisions, let's say in relation to their care and support arrangements, because of issues and difficulties around assessing, we have essentially not carried out a proper assessment, and we have unduly perhaps relied upon the assumption of capacity as an excuse not to intervene. The second error sometimes, but to be fair, this is pretty tricky, I think, in these sorts of scenarios, is not carefully identifying what the matter is that requires a decision. So, for example, if you're dealing with a very complex hoarding scenario, what is the actual decision at stake that you're assessing the person's ability to make? We do have a whole range of guidance from judges, but still that can be quite a challenge, I think. And then flowing from that, having identified what the matter is that requires a decision, sometimes those that are assessing someone's decision-making ability don't set out and explain to the person what information is in fact relevant, because we need to try to work out what the reasonably foreseeable consequences are of this decision before we can then go anywhere near trying to assess the person's ability to comprehend those. So if that's not set out, then sometimes that provides a ground for challenging the assessment. Fourthly, and interestingly, this has been mentioned as well, there are situations where, even though the act is and capacity is very time specific, there are situations where we need to take a longer view, this longitudinal approach, particularly when capacity is fluctuating. So I want to have a look at that. Judges also have come up with another approach called the macro-micro approach, which I'll say something about later on. And then number 5, really, I think if you're going to take one thing away from this talk, please take away number 5, because whenever we are trying to work out whether someone can make a decision, it's really important that we approach that on what I've referred to as a sort of 3-dimensional basis. So a 3D evidential assessment. And those 3 dimensions are essentially conversations with the person, conversations with those that know them, and then any kind of documentary evidence, safeguarding alerts, incident logs, etc., etc. So sometimes people are faced with a situation where the person's not willing to engage. They won't speak to me. There's an assumption of capacity, and we walk away describing this as a so-called lifestyle choice, which again is a term that I absolutely detest. Whereas in fact, if despite everything we've tried, if we can't engage and speak to the person that everyone is so worried about, that's not the end of it, because we might then have to form a view on their ability to make this decision based on those other dimensions. So what other people think about their decision-making ability, and also what we've read and considered. So that 3-dimensional approach is incredibly important, I would suggest, in these sorts of tricky safeguarding contexts. And then I think another theme that's coming out of these reviews is what some people call executive functioning issues. So I'm going to sort of reframe that slightly, because I think sometimes there's a bit of confusion about what people mean in this regard. So I'm going to be talking about situations where perhaps someone can understand the reasonably foreseeable consequences, of deciding whether or not to have help under the Care Act or whatever it might be, they might even be able to retain that information. The question sometimes is whether they can then use it. So I want to spend a bit of time on number 6, but essentially it's the ability to use what you know. Is one, I think, particularly important area. And then another common error, number 7, is we see a lot of opinion without evidence. And obviously, if we are going to claim or assert that someone can't make a decision, then we need to back that up with evidence. And obviously there are 3 sources of evidence: the person, other people, and what we've read. All right, so those are some of the sort of common errors that we come across. And of course, those are 7 potential grounds upon which an assessment of capacity could be challenged. So the second thing I want to look at is the principles of empowerment. And in Chambers, we've prepared a whole shed load of guidance notes that are hopefully helpful, which try to sort of summarize and simplify the law for you. So if you want to read more about this, then feel free to dig that out. So as we all know, there are 5 principles in the Mental Capacity Act: the assumption, the need for taking practicable steps, the principle relating to unwise decisions, and then we have the other 2, best interests and having regard to what's less restrictive. And so I want to focus mainly on the first 3 of those, and some of the criticism, I think, that has been made in some safeguarding adult reviews about a sort of misplaced assumption. Now, this is a quote from a judge in a very different context. This is an employment case, but the judge is looking at the Mental Capacity Act, and I think what's said in this paragraph sums up the issue really, really well. So the presumption of capacity is obviously important. And crucially, of course, the Mental Capacity Act kicks in at the age of 16. So the presumption is important. It ensures proper respect for personal autonomy by requiring any decision as to a lack of capacity to be based on evidence. Okay, opinion's not enough. The opinion must be based on evidence. Yet, he says, the presumption, like any other, has logical limits. When there is good reason for cause for concern, where there is legitimate doubt as to capacity to make the relevant decision, the presumption cannot be used to avoid taking responsibility for assessing and determining capacity. To do that, he says, would be to fail to respect personal autonomy in a different way. And so that, I think, sometimes is the challenge, where there is difficulty trying to engage the person. You cannot just walk away and rely on the assumption of capacity to avoid undertaking a proper assessment. And so what I've suggested there, particularly in these sorts of complex cases where often the risks are very high, if there is cause for concern, can you justify a decision not to carry out a capacity assessment? And also what I would suggest, because this is the document that would be relied upon very heavily if there was a serious safeguarding adult review or were still in the coroner's court, what I would suggest is that in these cases, it's just as important to evidence capacity as it is to evidence incapacity. And there is absolutely nothing wrong in doing so. So if, having done a sort of 3-dimensional assessment, if it is our view, in fact, that the person is able to make the relevant decisions, then evidencing that is just as crucial. Okay, so the more serious the risks are, the more you should document the risks that have been discussed with the person and the reasons why it's considered that they are able and willing to take those risks. Again, sometimes that's not done, when in fact it can be just as crucial. What if the person is unwilling to be assessed? or unwilling to engage. There's not an awful lot in the Mental Capacity Act Code of Practice about this. The third line of that first paragraph says, in these circumstances, it might help to explain to someone refusing an assessment why it's needed and what the consequences of refusal are. But threats or attempts to force them to agree to an assessment of capacity are not acceptable. So in other words, if we do have legitimate cause for concern about the person's decision-making ability and they're refusing to speak to us, then we need to explain what the consequences might be. And I say that's not a threat. Essentially, what we are explaining there is the assessment process, that we're really concerned about your ability to make this particular decision. And we have to assess that, and we will have to take into account, and we want to take into account your views on this, but equally, we will have to consider all of the evidence as well. And obviously, it would be more helpful to know what your views are, but if the person's not willing to speak to us, then we'll have to base it on all the other evidence that we have. This case of AMDC is quite helpful in terms of the second principle of the Act, the need to take practicable steps to help someone make the decision. So the judge says here, if on assessment the person does not engage with you, then you're not required mechanically to ask them about each and every piece of relevant information, if to do so would be obviously futile or even aggravating. But your report should record what attempts were made to assist the person to engage. So that's what we're focusing on here. What has been done to try to assist the person to engage, and what alternative strategies were used. If you hit a brick wall with the person, then you might want to liaise with others to formulate alternatives. You might want to consider if there's any sort of bespoke educational support that could be given, and failing to take steps or document those steps could be contrary to the Act. So again, it's about documenting the attempts and efforts that have been made to try and to promote the person's engagement and decision-making ability. And here I've just set out a number of examples. So obviously what the options are, providing information about what the reasonably foreseeable consequences might be, particularly, for example, if the person does not receive the care and support that's on offer. Again, another common theme, thinking about supporters as I've described them. So, you know, are there any sort of family members, any kind of advocate, whether that's under the Care Act or elsewhere, any trusted friends that could be involved to try and support the person to make this decision, as well as, of course, other forms of communication, etc., etc. All of that, again, will be familiar territory to you. And I think this is usually the big challenge. A person is not to be treated as unable to make a decision merely because they make an unwise decision. So often in these sorts of tricky, high-risk safeguarding scenarios, we are really trying to grapple with, is this a situation where someone is making a capacitous, unwise decision, or in fact, on a proper assessment, is it the case that they're actually unable to make this decision because of a mental impairment? And the courts have described this quite nicely without providing a huge amount of guidance, but nevertheless, the court has said there is a space between an unwise decision on the one hand and one which an individual does not have the mental capacity to take on the other hand. And it's important to respect that space, to ensure that it's preserved, for it's within that space that autonomy operates. But I would also add to that, sometimes it's within that space that sometimes the individual's dignity could be at risk. And so again, it's about trying to balance respect for autonomy and respect for dignity. Okay, so if we then look at the issue of capacity, the Supreme Court has, in the last sort of 18 months or so, reconfirmed what has been the position ever since about 2013, which is that if you're concerned about someone's decision-making ability, the first thing you do is not to ask, do they have a mental impairment or, you know, some kind of diagnosis. That's the wrong approach. The first thing you do is to assess their functional ability. And I think in the present context, that's particularly important because I anticipate that there are a number of situations where capacity hasn't been properly assessed because there is no diagnosis. And almost the lack of diagnosis is again sort of used as a reason not to go further. Well, that gets this the wrong way around. Okay, the first stage, the first limb, if you like, of a capacity assessment is the functional test. Are they able or not to make a decision for themselves in relation to this particular matter? And again, we need to think about what the decision is later on. And again, familiar stuff. Being able to make a decision involves being able to understand essentially what's at stake, including the reasonably foreseeable consequences of, for example, having or not having support or medical treatment, whatever it might be, being able to retain that long enough, being able to use and weigh that information, and communicating the decision. So it's functional first, I think, is incredibly important in these sorts of contexts. And only if the person is proven to be unable to make any or do any one of those things, do you then go on to ask, do they have a mental impairment? Yeah, a temporary or permanent impairment or disturbance affecting the functioning of the mind or brain, essentially a mental impairment. And again, in the present context, sometimes that can be really tricky. It doesn't need a diagnosis, importantly, but I think if you are in a situation where someone is potentially subject to neglect, whether that's self-neglect or neglect, or if you like, where there are unmet needs, which might be another way of describing it, then sometimes we will need a medical view as to whether or not there is a mental impairment. Because, of course, without number 2, we cannot use the Mental Capacity Act. We might end up using the High Court, the inherent jurisdiction of the High Court, because that does not require a mental impairment. Okay, but the Mental Capacity Act and the Court of Protection is only available if all 3 of these elements have been established. So, for example, let's imagine you're dealing with a really complex hoarding scenario, and we need to think about, okay, well, what's the decision at stake here? What information is relevant to that, including the reasonably foreseeable consequences? And let's assume, for argument's sake, that the person is unable to make that decision. We then get to the question of, well, do they have a mental impairment? Now, there might not be much at all in the way of evidence there, in which case we might need the input of health, whether that's a psychologist or a psychiatrist, for example, to work out whether there is a mental impairment here, whether that's hoarding disorder, for example, or some other impairment. Okay, so it's functional first, I think is the key thing that I would emphasize there. Now, judges have set out a load of guidance or guidelines as to information that's relevant to a whole variety of different decisions. And again, we've done a guidance note on this if you want to have a look at it in more detail. And this is aimed really to help those that assess decision-making ability. And I think what I would stress before we look at the guidelines is that these are just guidelines. They're not tram lines that you rigidly apply to every scenario. Okay, they are just guidelines. And so the courts have emphasized that, you know, they need to be tailored to the particular scenario. Now, assessing capacity is not a knowledge test. And the code says it's really important not to assess someone's understanding before they've been given relevant information about a decision. And every effort must be made to provide that in a way that's most appropriate to help them understand. So, you know, if you're talking about a situation of serious unmet need, then of course we all need to think about, okay, well, what are the reasonably foreseeable consequences here? And then explain that to the person. For example, I dealt with a case a while ago where this man had been paralyzed from the neck down, and he was at home living with his wife, and he had developed a grade 4 pressure sore, which was very, very close to his anus, and literally within days there was a risk that if that wasn't treated, then he could die. Now, in that case, he was refusing all help, and his wife didn't want any help either. So you've got a very high risk scenario where the person is refusing necessary medical treatment, and the evidence was that he was unable to comprehend the reasonably foreseeable consequences. So in terms of the functional test, he was unable to make a decision about treatment regarding this pressure sore, but it wasn't because of a mental impairment. So what do you do in that situation? Well, essentially, the reason he was unable to make the decision was because of the pressure, undue pressure, that his wife was exerting over him. And so that's a sort of classic case where we can't use the Mental Capacity Act or the Court of Protection, but instead we sometimes end up going to the High Court and the inherent jurisdiction. And sure enough, that's what happened. And he was removed from the home and taken to a nursing home for treatment. So we need to explain the information, the reasonably foreseeable consequences. And the courts have said at the bottom there, the assessment is not a general knowledge test. It's an assessment of whether the person has the ability to understand those matters when explained, to retain, use, and weigh. Okay. So these are just some examples. And the photo in the top right is incredibly important. Okay. That's there to remind us really that this guideline or guidance that's being given by judges needs to be calibrated. It needs to be tailored to the particular situation and choices that the person faces. Now, we're not going to go through this in depth, but it's just to give you a flavor, really. So if there were real concerns about the person's decision-making ability regarding where they live, that's the sort of information that's relevant when people are making that decision. I think what's probably more relevant is the second one, care. Is the person able to make decisions about their care and support arrangements? So typically, let's say we've had an assessment done under the Care Act, we've identified eligible needs, and we are offering arrangements to meet those needs, which the person is refusing. From a mental capacity perspective, the question might be, not necessarily, but the question might be, is the person able to make decisions regarding their care and support arrangements? Fine. Well, what information is relevant? What are the reasonably foreseeable consequences in that case? And again, judges have said, generally speaking, there tends to be 5 key things to grasp when you're making that decision. So what areas you need support with? There might be debate about that. So can you grasp what areas you actually need support with? What sort of support you need? Who would be providing it? And usually number 4 is the key one. What would happen if you didn't have any support or you refused it? So to what extent can the person understand, retain, use and weigh up that foreseeable consequence? And then finally, they can complain if they're not happy about their care. Now, again, these are guidelines. In some cases, we might not separate residence from care. In some cases, they might be part and parcel of one decision. Otherwise, there's a risk of what judges call incompatible silos. So just to put this into context, because again, this is, it's just a sort of fancy legal term to try and describe something really. The mental capacity is obviously decision specific, and we're told it's it's time specific. That's all fairly well ingrained, but sometimes people have been so specific about the decision that it's ended up with these sort of incompatible silos. And so judges have tried to sort of explain the importance of avoiding that kind of incompatible situation. And I think this Liverpool case is quite helpful, because the judge says that generally speaking, questions of care and residence are considered separately. But there are cases in which they would be intimately related. And just pausing there, obviously, this is a big issue, because the bigger the decision is, the more information there is at stake to grasp, and therefore the outcome of the assessment could be different. Okay, how you describe the decision and the information that's relevant can sometimes have a bearing on whether the person is able or not to make it. So sometimes there are cases where residence and care are intimately related. And he goes on to say, if one took the example of a person with serious physical disabilities, for whom the issue of residence would be inseparable from that of care, and one heard that the protected person was rejecting of care because they were unwilling or unable to recognize the necessity for it, that would inevitably impact on the question of capacity to make decisions about residence, where care would be a key ingredient. Okay, and he goes on to say, when dealing particularly with severe emotional difficulties and deficits, and we've heard about trauma already, it can be very artificial to assign the relevant questions to individual pigeonholes. They are deeply interrelated and have to be considered in the round. And again, we've heard about holistic approaches being taken. Essentially, this is suggesting that in some cases that sort of approach is required when it comes to issues of capacity. It would be artificial, he says, and indeed wrong in this case, not to consider residence and care together. It is her fundamental inability to grasp why she needs support and what would happen if she didn't have it that underpins my finding that she lacks capacity in both these areas. She could not choose between packages of care because she seriously overestimates her ability to protect herself and seriously underestimates her own vulnerability. So I think that's quite a useful, I hope that's a useful example in the context of a situation where someone is refusing care and support, where you might have to think quite carefully about the matter that you've identified as requiring a decision, because even though it's decision specific, sometimes decisions are intimately related or inseparable, where in fact you need to consider it on a larger sort of scale. Now, if you're with me in the afternoon, in terms of workshops, I've put together a bit of a complex hoarding case, and that's kind of based on a case that I was doing recently. It's still ongoing actually, but essentially AC and GC is the first court of protection decision that really tries to grapple with the issue of hoarding. And in a nutshell, you've got mother and son who lived together. Husband died about 10 years before, since which both mother and son have been hoarding significantly, and it was a very extreme hoarding case. And mother had previously been removed to a care home whilst the hoarding issues were addressed. She was found to have capacity to make decisions about her residence and care and chose to go back home. And then about 18 months later, the risks again sort of materialized from the extent of the hoard and unmet need. And in short, one day her son, who was her only carer really, didn't return one evening. Mother panicked. She's in her early 90s. She panicked, phoned the police, and they turned up, were quite shocked at the living conditions, and paramedics removed her to hospital. From hospital, so it was like a sort of social care admission really. From hospital, she was then discharged to a care home and was battling to go back home. That's the sort of the nub of it. And so in this decision, it's sort of an interim decision last summer, the main issue for the judge was whether it was in this lady's best interests to spend the rest of her days in a care home or to go back home and live with her son. But we asked the court to give some guidance in relation to some of the complexities regarding hoarding, because both mother and son had been diagnosed by a psychologist as having hoarding disorder, which is important to note is a can be a mental impairment in and of itself. And one of the issues was, well, if you're faced with this sort of situation, what is the decision at stake? Now, obviously, in this case, there was a lot of issues around residence, care, etc. But the focus was very much on the hoarding. And so the first interesting thing I think about this case is that the judge identified the decision as relating to the person's items and belongings. Okay, because the capacity of both mother and son to make that decision was in question. Okay, so in the context of hoarding, the focus was very much on whether mother and son were able to make decisions in relation to their items and belongings. Not, managing their property and affairs more generally, not about care and support. The focus was very much about items and belongings. And so the second question then is, okay, well, what information is relevant to that? Because again, we didn't have any case law on this. This is the first case of its kind. And again, the judge provided some guidance, which again, you'd need to calibrate depending on the sort of situation that the person and you face. So based on some of the assistance from the expert, the information that was relevant consisted of, I think, 5 key things. So firstly, the volume of belongings the person has and the impact that has on the use of the main rooms, the main living areas. So if you were assessing someone's ability to make decisions regarding their items and belongings, you'd have to consider the functional test. Can they understand, retain, use and weigh up the relevant volume of belongings and the degree to which those impair the usual function of the important rooms in the property? So the extent to which they impair, for example, the use of the bedroom for sleeping in, the use of the kitchen for the preparation of food. Secondly, in terms of reasonably foreseeable consequences, you'd be assessing their ability to comprehend safe access and use. So to what extent can the person, are they able or not to safely access and use those living areas? Thirdly, the creation of hazards. Can they comprehend the extent to which these accumulated belongings create actual or potential hazards in terms of their health and safety? And again, I'm not going to go through all the detail. It's just the sort of headlines that I want to capture. And then in some cases, they lived in a dormer bungalow and there was a hell of a lot of stuff upstairs. Sometimes the accumulation of belongings threatens the safety and integrity of the building itself. So if that is a risk, if that's a reasonably foreseeable consequence, again, to what extent can they grasp that risk? And thirdly, what we also need to comprehend is that it's possible to safely and effectively remove or dispose of hazardous levels of accumulated possessions. And again, if the person cannot grasp that because of hoarding disorder or some other mental impairment, there would be a lack of capacity to make that particular decision. Okay, so again, we can explore this in more detail in the workshop, but essentially it's quite a useful case, I think, in terms of identifying what the decision is, or a decision in a hoarding case, and the information that is then relevant. And in this case, mother was unable to make that decision, but also importantly, the son was unable to make that decision. And the reason he was unable to decide this was essentially because even though he was fully aware of what the risks were, he could understand, he could retain, what he couldn't do was use that information because of hoarding disorder. He couldn't apply his understanding and knowledge to and deal with the risks that had been presented. So in this last session, I just want to focus in on when to challenge a capacity assessment and what does a good one look like and when to pick a bad one. This is an Australian case, but they looked at the Mental Capacity Act in this country. And again, I think quite nicely summarize the proper approach we need to take. So any assessment of capacity needs to be criteria focused, functional stuff, understanding, retaining, using, weighing. It needs to be evidence based. It needs to be person centered and non-judgmental. And so if you have a sort of debatable capacity assessment, these are perhaps some of the things you might want to explore. Or similarly, if you're doing the assessment, these are some of the things you might want to bear in mind. So who should be involved in the capacity assessment and who should lead on it? That will very much depend on what the decision is and who knows the person best. Practicable steps, really important. If there's a number of people involved in these sorts of multidisciplinary approaches, do we agree what the decision is and what the salient details are? The relevant information, the reasonably foreseeable consequences. So typically, there might be evidence coming in from the fire service. Let's have a look at, what actually is the risk of fire in this case. Do we agree on that? And then the fourth point really is about evidence, as opposed to opinion. So where is the evidence in terms of the functional test, the mental impairment, and causation? And finally, is the opinion based on that evidence? Because if there isn't the evidence to support it, then it's not really worth the paper that it's written on, to put it bluntly. So sometimes there are issues about fluctuating capacity. We don't need to go through this case in any depth, but essentially it's quite a useful case, Cheshire Western PWK, because one of the issues was around this young man's ability to make decisions about his care and support arrangements. And essentially the judge distinguished between what he called isolated and repeated decisions. So sometimes people make a sort of one-off isolated decision, let's say, I don't know, to create a lasting power of attorney. And the focus is, at the time, could they decide? Contrast that with repeated decisions, or what I tend to describe decisions of a continual nature, where, you don't make the decision at 11:59. In fact, this is a decision of a more sort of continual nature. And if you've got someone that has really significant sort of care and support needs, then that might be a decision of a continual nature. Similarly, managing your financial affairs is a decision of a continual nature. You don't do that in a very time-specific approach. And so what do you do in that case? Well, with these sort of longer term decisions, when it comes to capacity assessments, you can take a longitudinal view. So you can look at how the person is able to make this decision over a longer period of time and form your judgment or determination accordingly. Okay, so that longitudinal view is an approach that's open to you if you're assessing someone's decision-making ability regarding a decision of a continual nature. And then in terms, like, we've had some so-called kind of self-neglect. Oh, sorry, that's my watch talking. Sometimes we've had some cases involving self-neglect in the context, for example, of managing diabetes. So this is a slightly different approach that judges have suggested. Rather than longitudinal, they sort of describe what's said to be a sort of macro decision as opposed to micro decisions. So managing your diabetes, you know, that's a big decision. That's a macro decision. There's lots of tiny individual or micro decisions that form part of it, but essentially managing your diabetes is a big kind of overarching macro decision. Again, this is really important because someone might be able to make the tiny decisions, the micro ones, but be unable to make the overarching or global decision as the judge has described there. So, you know, the micro decisions are sort of, you know, your diet, testing your blood glucose, administering insulin, going to hospital when necessary. Those are micro decisions. But the big one is about your ability to manage your diabetes, diabetic management. And then the final thing I want to talk about is this so-called executive functioning issue, which again comes up quite a lot in serious or safeguarding adult reviews. Now, the first thing I would say about executive functioning is that this is nothing new. This seems to be quite a topical issue and has been in recent years, but it's nothing new. It was recognized way before the Mental Capacity Act was introduced. And the Law Commission identified situations where, and it's worth just reading this out, there are cases where the person can understand information, but where the effects of a, let's say, mental impairment prevent them from using that information. Okay, and that's what I'm focusing on here, the ability to use. They go on to say, we explained previously that certain compulsive conditions can cause people who are quite able to absorb information to arrive inevitably at decisions which are unconnected to the information or their understanding of it. Another way they describe this is common to all these cases is the fact that the person's decision is divorced from their ability to understand. And at the bottom there, a decision based on an inability to act as a result of mental impairment is not a decision made by a person with decision-making capacity. So this sort of challenge, if you like, to put it in sort of layman's terms, the difference between talking the talk and walking the talk, that's the sort of situation here that the Mental Capacity Act can address. So typically, bringing this back to the statutory test, typically where there are issues of executive functioning, you know, this isn't a separate capacity test, right? You cannot have capacity under the Mental Capacity Act but lack executive capacity. That just would be a nonsense. Instead, what we're talking about is situations where someone typically can understand what's at stake. They might even be able to retain that information, but the focus is on their ability to use and weigh the relevant information. So I might be able to fully understand all of the risks involved in this sort of self-neglect or unmet need scenario. I might be able to retain all of that information as well. No issue about recall, but I can't act on it. So there might be an issue about my ability to use that information. Okay, now these are really complex capacity cases. And there's a bit of guidance provided by NICE where they talk about executive dysfunction. But what I quite like is the case law, where in the middle there, the judge describes executive functioning as the ability to think, act, and solve problems. So again, if you're thinking about a sort of self-neglect scenario, this is really relevant. The ability to think, act, and solve problems, including the functions of the brain, which help us learn new information, remember and retrieve the information we've learned, and then crucially use the ability to use this information to solve problems of everyday life. And judges emphasize the need for real world observation. So if there are issues or doubts about the person's ability to use and sort of apply their knowledge of the risks to the situation, then you might need to look at this in some depth. A three-dimensional approach is absolutely critical. So at the heart of it is the matter. So let's say the issue is about, can the person make decisions about their items and belongings? Okay, you've got a really significant hoarding case. The risks to them and potentially to others is incredibly high. We've got a multidisciplinary approach. Everyone is, they're being kept awake at night because of this case, and the person is either not engaging or refusing to do anything about the risks. Well, even though they might understand and retain, can they use? And you do need to tread carefully here, because we often say things and then do something different. Okay, and we might say one thing and do something else for all sorts of reasons, whereas the Mental Capacity Act is only interested if there is, if you like, on the right there, evidence of repeated mismatch. So there must be evidence to demonstrate that there is this conflict, I would say, this divorce, to use the Law Commission's word, this divorce between what the person is saying and what they are doing. Okay, now you sometimes do get these sorts of cases in the context of brain injury, but it could also arise in all sorts of other scenarios, such as hoarding disorder, where you've got this conflict or divorce between what they're saying and what they're doing. And so it's really important that we approach this in a three-dimensional way so that we know what the person is doing, because you need that evidence, that real world observation that you can then put to the person to see how they explain it. How do they account for this discrepancy, this mismatch? Is it a situation where, they are unable to remove or dispose of hazardous belongings because of the anxiety and distress that might arise as a result of hoarding disorder, for example? Now, the draft, obviously the Mental Capacity Act Code of Practice is being updated, and we have a draft of the new code. This might change before it's finalized, but the draft does try to help us when it comes to issues of executive functioning. And essentially, I won't read it out, but essentially those two paragraphs illustrate what we're discussing. So there must be a clear evidence of repeated mismatch. We need that evidence that clearly sets out this conflict or divorce between what the person is saying on the one hand and what they're doing on the other. And the code says that you're going to need more than one single assessment. So this will have to be done on a sort of longitudinal, over a longitudinal period. And they also say in the draft code, a series of unwise decisions may indicate an inability to use. And so it's really important, if you sort of end up in this sort of area where you think actually the person is unable to use their understanding of the risks, you need to explain that. How and why are the person's difficulties with executive functioning causing them to be unable to make the relevant decision? How does the person account for that significant discrepancy or conflict between their ability to sort of respond to questions in the abstract and their inability to act when faced with concrete situations? Because if we fail to carry out that sort of detailed assessment of capacity, that can expose the person to substantial risks. So those are the things we've covered, some of the common errors, the importance of the three empowerment principles. We've looked at decisions and relevant information and when to challenge a capacity determination. So I'll just pause there.